A thread by Eric Schmidt, the Attorney General for the state of Missouri. St. Louis prosecutor Kim Gardner is engaged in a political prosecution. I entered the case seeking a dismissal. As Attorney General, I have a duty to protect the fundamental rights of all Missourians, including the right to keep and bear arms in self-defense of one's person and home. A thread. The right to defend one's person, family, home, and property has deep roots in Missouri law. Self-defense is the central component of the right to keep and bear arms, which receives the highest protection from the Missouri Constitution. Missouri statutes specifically authorize citizens to use firearms to deter assailants and protect themselves, their families, and homes from threatening or violent intruders. A highly publicized criminal prosecution of citizens for exercising these fundamental freedoms threatens to intimidate and deter law-abiding citizens from exercising their constitutional rights of self-defense. The prosecution sends a powerful message to all Missourians that they exercise their fundamental right to self-defense at their peril. Missourians should not fear exposure to criminal prosecution, even prison time, when they use firearms to defend themselves in their homes. I have a duty to protect and defend the constitutional and statutory rights of Missourians, including the constitutional right to keep and bear arms and the right of self-defense by way of our Constitution and Missouri's Castle Doctrine. I have entered the case and filed a brief seeking a dismissal of the case to ensure all Missourians who wish to exercise their fundamental right to defend themselves, their families, and their homes without fear of criminal prosecution. This case is extraordinary. Based on widely reported facts, this prosecution targets conduct explicitly protected both by the Missouri Constitution and statutes, setting forth the Castle Doctrine of self-defense. In other words, this is not just a case of the government retaliating against a citizen for exercising a fundamental right, which is bad enough. It also is a case where the local prosecutor believes that exercising that fundamental right is itself a crime. This political prosecution is not based in law, and as long as it continues, it will send a public message to all Missourians. If you dare to exercise the fundamental right to keep and bear arms in defense of family and home, you may be prosecuted and sent to prison. The right to keep and bear arms in self-defense of one's person and home receives the Missouri Constitution's highest level of protection. Self-defense is the core lawful purpose and the central component of the right to keep and bear arms in both the Second Amendment and the Missouri Constitution. See the Heller decision. This core and lawful purpose includes the right of law-abiding, responsible citizens to use arms in defense of hearth and home. See Heller. The right to keep and bear arms is a fundamental right that is necessary to our system of ordered liberty. See McDonald case, Second Amendment. The founders viewed the right to keep and bear arms in self-defense as a natural right that was inalienable. This recognition predated the adoption of the U.S. Constitution and had deep roots in English concepts of liberty forged in the Glorious Revolution of 1689. Thus, under principles of English law that the founders viewed as fundamental, the right to keep and bear arms was a recognition of the natural right of defense of one's person or house as part of the law of self-preservation and central to the Second Amendment. The founders knew the right to keep and bear arms, not the government, is the citizen's first line of defense against physical attack. Thus, this right received its greatest emphasis during times when government could not be trusted to protect citizens' personal security. The landmark Heller decision mentions its importance for anti-slavery advocates, and post-Civil War firearms for self-defense was often the only way black citizens could protect themselves from mob violence. If anything, this right is even more deeply rooted in Missouri's unique history and tradition. The right was explicitly in Missouri's first Constitution of 1820, stating, "The right to bear arms in defense of themselves and of the state cannot be questioned." Missouri has even expanded this language over the years, including in 2014, when the overwhelming majority of Missouri voters included the language home, person, family, and property subject to strict scrutiny. It goes on. The state of Missouri shall be obligated to uphold these rights and shall under no circumstances decline to protect against their infringement. By enacting the Castle Doctrine of Self-Defense, Missouri statutes explicitly authorize the use of firearms to defend one's person, family, home, and property from threatening and violent intruders. Missouri has adopted one of the strongest versions of the Castle Doctrine in the country. This doctrine is not merely a creature of statute, but deeply rooted in the constitutional right to keep and bear arms. Section 563.031 specifically authorizes Missouri citizens and homeowners to protect themselves from illegal invasions and intrusions into their homes and private property. It establishes 3 principles. 1. Missourians may defend themselves and others using physical force, including firearms, to deter the imminent use of unlawful force by another person. 2. Missourians may use deadly force against a person who unlawfully enters or attempts to enter private property owned by another and threatens to use unlawful force against another. 3. Missourians have no duty to retreat from their own residence or property when threatened by an unlawful intruder. Further, the Castle Doctrine specifically shields Missourians who act in valid self-defense from prosecution for unlawful use of a weapon by exhibiting a weapon in an angry or threatening manner under 571.030.1, Section 4. In fact, 571.030.5 states, "It shall not apply to persons who are engaged in a lawful act of defense pursuant to Section 563.031. Thus, this is not a case where the Ds must raise a self-defense as an affirmative defense or assert the exercise of a constitutional right as a defense to justify conduct that otherwise would constitute a crime. Exhibiting a weapon in an act of valid self-defense is not a crime at all. The law is clear and unambiguous. If an intruder invades private property and threatens to harm the homeowner or another person, a citizen may defend him or herself. To display firearms in self-defense, as in 563.031, is not a crime, and it should not be charged as a crime at all. The highly politicized prosecution of Missouri citizens for exercising their right to keep and bear arms in self-defense may intimidate and deter other Missourians from exercising their fundamental right of self-defense. This case reflects the opposite of the state's constitutional obligation under Article 1, Section 23 to uphold these rights, to keep and bear arms, self-defense, and protect against infringement. In fact, this political prosecution sends a powerful and dangerous message. You exercise your right to keep and bear arms at your own peril. If you do, you may find yourself in prison. This case has significance that extends well beyond the parties. The tendency of this case chills and deters all citizens from exercising one of our most fundamental rights, which receives the highest level of protection in Missouri's Constitution and laws. On behalf of all Missourians who wish to exercise their right to keep and bear arms in self-defense of their persons, homes, families, and property, and as Attorney General of the great state of Missouri, I am seeking a dismissal of this politically motivated case at the earliest opportunity.